Okay, everyone, I think we'll get started. I'm Tony Tanke. I'm the instructor for this course, and we are going to operate very informally, meaning I want you all to be comfortable. If you need to get up at any time, go get some more food or whatever, please feel free to do that. It doesn't bother me when people come in and out, or they're around or they're doing things. And the other thing is, I can be interrupted at any time. Don't worry, I won't lose my train of thought. If something is confusing, if you don't follow what I'm saying, please interrupt. And that's true with respect to any part of what we do in this class. I think first of all, what motivated me to do this, I'm a lawyer by profession. I am still practicing law. I've been practicing it for more than 40 years. I could never get it right, so I just keep practicing. As a part of what I've done, I spent 5 years with the California Supreme Court as the Senior Judicial Staff Attorney to the Chief Justice, which means that I wrote judicial opinions. I gave advice on what the law of California should be and how it should operate. And part of the job there was to read the decisions of the United States Supreme Court. And of course, we, like every state Supreme Court in the country, were inferior to the US Supreme Court on any federal law issues. So we had to keep up to date. And I wrote draft opinions for my boss that both declared state statutes unconstitutional and also applied all kinds of federal law. And so I had to keep up to date on this. And I noticed recently we are on the cusp of what might be truly a revolution in American law coming from our United States Supreme Court. And I was not up to date on many of the areas of law. And so I'm here for selfish reasons. This is going to keep me up to date because I'm going to have to read this stuff and I'm going to talk to you about it. And so the way we're going to operate, this first session is going to be sort of an introduction to the Supreme Court, how it operates, and what we can expect from it in the next couple of weeks, which are the last couple of weeks of the session. The Supreme Court will finish its October term on the 1st of July. All of the decisions that it has considered and all of the cases it has heard in this term will be released by that time. If they are not released by that time, they have to be formally continued to next year and re-argued. So they try to get them all done and get them all out because they have a new batch coming, in the next October term. They start in October. And so this is the big pile of decisions. And there are many truly momentous issues that have not yet been decided. And so we're awaiting those decisions. And so what we'll do after an overview this time about where the Supreme Court is and where it might be going, we will, in subsequent sessions, we will take particular decisions, and I'm going to identify the ones that I think are most important to speak with you about. And then the format will be, I'm going to describe the decision that will avoid your having to read decisions that run about this thick, because every one of these justices has to get their opinion in for the sake of history on most of these big issues. So, but I'll summarize it and then we'll discuss it, particularly with reference to what kind of impact is this decision going to have on our government, but also on our church, on our daily lives. That's going to be the chief focus of this. And so most of that's going to come from you. I want to hear from you on what you think. I can offer, of course, some legal thoughts. So far, we've had one major decision come down, and that's the abortion decision that overturned Roe versus Wade, the Dodd decision. That one, ladies and gentlemen, is a dream for lawyers. There is so much litigation going on now in states all across the country on the abortion issue that it's keeping many lawyers fully employed. And we may see the same thing in several other areas here. And so, you know, but what's good news for the legal profession may not be at all good news for the rest of us. So we'll focus on those kinds of issues. And particularly, the thing that I want to talk about first is that I want to give a little bit of foundation on the court and its role. We're going to try to understand at a basic level what the court is all about, what it's supposed to do, how it was designed, and I've given you Article 3 of the United States Constitution. 2 pages. The decisions that will come down just this term, 1,000 pages or more, interpreting that document, parts of that document. Few other areas of federal law, but mostly that document. So this is, by the way, about the shortest judicial clause in a constitution that's ever been written. The United States Constitution is remarkably concise as a whole, but this is really concise. So we'll talk about the specific language here and how the language tells us how the court operates. Okay, I will give you an overview here. In this session, we'll talk about the court as an institution, its foundation in the articles that I just handed to you, and its current operations. We are going to refer to one of the decisions in an area that you're, I think, pretty familiar with from news media, and that's the Second Amendment right to bear arms. That right is a right that's undergoing more and more development in the U.S. Supreme Court, and there's been a decision this term that we'll talk about briefly, and we'll use that as kind of an illustration of how the court operates and how it decides things and how it reasons. Then in part 2, the next session next week, we're going to talk about voting rights, a terribly important issue. That is an issue that does have some constitutional text attached to it, but it's mostly the Voting Rights Act, which is a federal law that's enacted to enforce parts of the Constitution. But the impact of that, including the recent decision involving Alabama and what happened there, and the impact that that had in relation to some other decisions, very, very important area, particularly not as important for us here in California, but in many other states. This is going to be some very critical stuff because people are being cheated out of their voting rights by the gerrymandering approach in many states, and this will deal with that subject. The second thing we're going to do next time is talk about administrative agencies, and there are 2 decisions that have come out so far that deal with the power and authority of administrative agencies on the federal level to make rules. And this is a kind of an interesting phenomenon. When we were all civic students in high school, we learned there are 3 branches of government. And we'll talk about those today: the executive, the legislative, and the judicial, right? Those are the 3 branches. Well, there's actually a 4th branch, not mentioned in the United States Constitution at all, but that is just as important to our daily lives, and that is the branch that we call administrative agencies or administrative law. It comes from legislation by Congress creating agencies like the FCC, like the FDA, you know, for whom one of our daughters works. And these agencies make rules, and those rules are binding federal law, and those rules actually govern us a great deal more than many of the other things that Congress itself enacts. So we're going to talk about that because there's a change in the court's view of what administrative agencies can do, how broadly they can regulate. The EPA is another one of these, and one of these cases involves the EPA, and we'll talk about that next time. Number 3 is the blockbuster, and I've left this one because the cases are not out yet. Look day to day, watch your news media because they're going to be dropped on us very quickly here. The affirmative action decisions. There are 2 of them. There's a case against Harvard University and another case against the University of North Carolina challenging admissions policies and practices that have a racial component as an element in admission decisions. That was consistent with current law. Those universities are in compliance with current law. But whether or not they're going to be in compliance after these decisions is at this point unknown, but we will find out sometime in the next 2 weeks. And then finally, I've left the best for last, the abortion decision, the Dobbs decision there. And we may also, and I want to get your suggestions on this. If there are particular decisions that have been decided this term that you are concerned about and would like us to cover, I'll be happy to take some suggestions and we'll go over those because there are many more. I don't know, have any of you heard of the Indian Child Welfare Act?
Yeah.
That's important.
Coming down yet, this term on the Indian Child Welfare Act. Yeah.
Was that act involved in this one case where this family adopted a girl? And then they had to give her up again because supposedly she had a great grandmother who was a member of some tribe.
Yes, that's exactly what we're talking about here. When I was working with the California Supreme Court, we used to get these cases all the time. And typically it would come up where you had an adoptive parent that had been through the whole vetting process for adoption. They were ready to adopt an Indian child, and all of a sudden the tribe intervenes and someone from the tribe steps in and they say, no, the child must remain within the tribe. And that's what the Indian Child Welfare Act does. The usual tests we use for deciding child custody are set aside in the case of Indian tribes. And we used to get these cases. I remember I used to get them and I would get a case and I'd have to write a memo to the court on what to do about these cases. And it was very frustrating because I didn't like the results of many of the cases. But on the other hand, we hadn't had a challenge brought yet. And our court was not inclined and wouldn't reach out to decide major federal law issues like that. And so, there wasn't anything that we could do about it at that point. But this may change. But anything else you're interested in, please let me know. So, okay.
Tony, you mentioned a handout. Sorry, on Zoom. You mentioned a handout. How can we get a hold of that? How can we get a copy of your screen sharing?
Okay, Cameron, you won't need to worry about the handout because I have it all on the PowerPoint slides as well.
Can you see the
Can you send us a copy of the PowerPoint slides?
Oh, definitely. We can.
Cool.
And I do have also. I also have hard copies for anybody here, but that is an issue with hard copies. I've got to keep that in mind. We'll have to find some way to post, what we're doing, and get it to those of you who are here on Zoom. But as I say,
recorded.
Pardon?
It is being recorded.
Yes. Oh, yeah. The whole thing is being recorded.
I can email any of this stuff.
Oh, sure. Yeah. We'll take the Zoom list and email the stuff.
But we'll get her a copy.
Okay.
Hand it to her. We'll take one to. Chuck can take one.
Oh, you'll be seeing her, okay.
Yes.
Okay.
Thank you, Chuck.
Let's talk about judicial powers in the Constitution. Article 3 defines judicial powers, which are balanced by executive and legislative powers. Here is the first sentence, and we're going to go through word by word, a couple of these sentences. The judicial power of the United States shall be vested in one Supreme Court, and such inferior courts as Congress may from time to time ordain and establish. Okay. So, what do we have there? One Supreme Court. Only the Supreme Court is constitutionally created. All the federal courts we have in this country are created by Congress, except for the United States Supreme Court. And it is up to Congress to create them. Congress did create a few of them in 1789 when Congress was enacted, when the Constitution was enacted. But what's happened since then? Wow, we have a terrific number of federal courts. We have what do we have? 13 circuits which handle appeals in the federal system. And we have probably about 600 or so federal district court judges that sit at the trial level where there's a single judge. For us, it's here in Sacramento. We have the Eastern District of California there. And so we have a three-tiered system in the federal system. And we have maybe about 800 judges total in the federal system, something like that. And the federal district courts, every state has at least one district for the state, but most states have more than one district. So more than one federal judge sitting there, sometimes quite a few. But still, most of our judges, a vast number, of course, are going to be existing at the state level. We have, as I say, 800 federal judges. In California, we have 2,000 judges.
Really?
We have a three-tiered system as well. California Supreme Court, California Court of Appeal, and the superior courts. We call them superior. It's kind of a funny term to use for them. They used to be superior because there were a bunch of municipal courts and other courts that were under them. Now all that's been merged, so they really aren't superior to anything in the judicial system, but they're called the superior court. In New York State is the funniest example of this. The New York trial court, where there's a single judge, just like it is in the Superior Court here. You go to that court, there's a single judge there. They try cases to juries and sometimes to judges. But that court in New York is called the Supreme Court. Because there were some inferior courts there, and they wanted to say, well, this court is supreme to those courts. Well, yeah. But then they had to put appellate courts above that, and so the Supremes don't make a lot of difference. So okay,
Question?
yes,
So when we go to be on a jury in Yolo County, is that the Superior Court?
that's the Superior Court.
Okay.
Yes, that is it. They're all superior now.
Okay.
Everybody's superior. It's just-
Yeah.
It's like what they call the great inflation thing. Everybody gets an A. There used to be, as I said, there used to be a municipal court, but those judges overnight, they got promoted automatically and they became superior court judges. So that's the way the system is there. So now, okay, why a Supreme Court? The Constitution and the laws of the United States, which are made in pursuance thereof, and also treaties, I didn't put that long phrase in there, shall be the supreme law of the land, and the judges in every state shall be bound thereby. The Constitution or laws of any state to the contrary notwithstanding. Okay, what is this? This is what we call the supremacy clause. This is supreme. It elevates what's going on in this country with respect to federal laws. Federal laws overcome every other law of the state. So for example, a lot of the job that I did when I was working for the California Supreme Court was to interpret the California Constitution. And at the same time, we would have cases where we had federal statutes passed by Congress, or maybe federal rules or regulations, of the FDA or the FCC or some other federal agency. Well, one would think that, my goodness, here is the California state constitution governs the whole state of California. And here's a federal regulation from some agency. Boy, certainly shouldn't that California constitutional provision triumph over this little regulation? Answer is no, no. Federal triumphs. So whether it's a federal decision of the United States Supreme Court, or whether it is a statute passed by Congress, or whether it is a regulation, it's federal. And so it overcomes anything to the state. Yes,
So
Bob.
what you're saying basically is that federal law, if someone here finds a federal case or federal law that was passed by Congress, that it would then supersede the Superior Court, but then the Superior Court would have to consider that law?
Yes, absolutely.
Can you repeat the question, please?
Absolutely. The question is, would a Superior Court sitting here in Yolo County, for example, have to consider a federal law as superseding, all of the state laws? And the answer is yes. Quite often, there are all kinds of lawyers who go into the superior courts and they file briefs and they argue federal law to that court, because that court has to follow federal law. And if it doesn't, well, there's a court of appeal above that in California, and there's a Supreme Court above that, and they're there to make sure that that federal law gets followed. We when I was at the Supreme Court, we wrote opinions on federal law. We had to interpret federal law. Now, of course, the opinions that we wrote, because of the supremacy clause, could always have been reviewed by the United States Supreme Court if it wanted to do so. But guess what? What does the United States Supreme Court do? They get asked to review about 8,000 cases every year. How many do they pick?
Over July 1st,
Over July 1st.
the Supreme Court's.
What's the comment?
Session is over.
Yeah.
They're talking to each other.
Oh, they're talking to each other. Okay. So 800 requests or 8,000 requests. How many of these are granted in a year?
8 maybe?
About 80, actually. They actually decide 80 cases.
We hear about
They
it.
grant 80 cases, but they have to pick 80 out of 8,000 first. And then they have to decide them in one term. And then the next term, the whole thing gets repeated again. That's the way that their business works. They spend a lot of time just deciding cases. It used to be, they would, cases would pile up. This is before the electronic era. They would all take a big pile of what are called petitions for writ of certiorari, which is the term you use for a request made to the US Supreme Court to review a lower court case. That's what you do if you're a lawyer. You put together one of these petitions and you ask the court to review this case. Well, they would let those things pile up while they were writing decisions and deciding those 80 cases that they actually decide in a year. And then they get to the end of the term and, oh my gosh, look at this pile. I mean, you're talking about roughly 8,000 cases a year, and most of them would come in during that time. So they would literally have them all piled up in boxes, and wherever they were going to spend their summer. And, Justice Douglas used to spend it in Yakima, state of Washington. So he'd have his boxes all shipped up there with all of these petitions. And that's what they did over the summer. They had finished all their cases from last year. They would just look at these petitions and then try to pick out the ones that are going to be the 80 for next year. And it's a kind of an interesting process. We had to do something similar in California. We grant about 5% of our petitions, but we don't have 8,000, thank goodness. We do have about 3,000. Grant, as I say, about 5% of that. But Justice Brennan used to say, you give me one of those petitions and I can tell whether this is something we're gonna grant in 60 seconds. You just crack the cover, you look at the first section, which has to be, what's the issue presented for review? And I can read that and I'm ready to vote. Well, by and large, I'm sorry, yeah, that's, I mean, he may be right. But you still gotta go through 8,000 of them. It's a big pile, and there may be many of them that are just, no, we're gonna throw this one out, we're gonna throw this one out, we're gonna throw this one out, yes.
So are they divvied up among the justices? Each one takes 4 or 5 boxes, or do they each have to go?
They
through all
each do them
8,000?
all, they each do them all, and their law clerks with them. Yeah,
And these petitions, are they like 50 pages or something?
no, the typical petition is anywhere from maybe 20, 25 pages, something like that. But the key part of it is that first couple of pages where the issues are laid out. Is this a federal issue? First of all, it's got to be a federal law issue. And then how important is it? What impact is this going to have on the country? Then there are all kinds of procedural things about, can we get to that issue and review this? But first thing you got to do is decide whether that issue is important, and they do that.
You mentioned
Yeah.
law clerks.
Yes.
I mean, I assume an
Yes.
awful lot of the work of that is done. They have
Yeah.
pretty good sized staff.
Law
That's
clerks
pretty important.
do file through, and justices will say to their law clerks, and when I was a law clerk for 2 years for one Minnesota Supreme Court justice and then a federal judge in San Francisco. And then I worked for the Chief Justice for 5 years. So I spent about 7 years of my career, looking at these kinds of things. And my boss had certain kinds of things he wanted us to be looking for when we had a petition. We call them petitions for review in California. And so we had to pick those things out of the pile. And we came from an era, I was working there in an era of change. And it was not change in a progressive direction. Some of you remember 1986, the Great Revolution, including the guillotine for 3 California Supreme Court justices who were voted out in a retention election. We have yes, no voting every 12 years for appellate judges in California. We say yes or no. Most of us look at those and we don't know who these people are or what to do or anything. And so being good, positive people that we are, we usually vote yes on those choices, unless there's a reason to vote no. Well, they mounted a publicity campaign against those 3 justices because of their death penalty records. They were reversing, overturning death penalty cases. Death penalty was quite popular in California in the late 1980s. And so that was a popular cause to attack the Chief Justice and 2 others.
Well, I remember it was an initiative. It was probably not very well written that they were voting against.
Oh,
Not
yeah.
that they were against the death penalty here. They just
They're-
thought the initiative that had been passed by
They had
public was
trouble.
terrible.
There had been an initiative and they were interpreting various parts of it. There were problems with the initiative, but that's a legal detail to members of the public, who are voting on this. They see, for example, I think the rate at the time of that election went up. The court had affirmed or upheld 3 death penalty verdicts, overturned 35 or so. So that was something that was of concern to the public. But what was going on underneath that? And most people didn't understand. There was a campaign. Business hated the California Supreme Court at that point because it was pro-consumer and it was making all kinds of decisions that were in that direction. And so they provided the money for a campaign to bring to the attention of the voters, look at what they're doing on the death penalty, which of course had nothing to do with the issues that they were really concerned about. So vote no. And they motivated. So 3 of the judges were got off, and then were replaced by 3 others. And I wasn't there when that happened. I joined the court in 1989, 3 years after that happened. So we were in an era in which the court was conservative. It had developed a more conservative base, and it was wanted to take the law back in a more conservative direction. So, you know, I had a lot of discretion in my position, and so I usually looked for things that I knew my boss would accept. There's no point in you know, spending a lot of time on something your boss is not going to approve, because ultimately it wasn't my vote. I had to write something, but it had to be approved. So I would pick things that he would find attractive. For example, one of the things that happened, and I get a kick out of some of these things, but we had an attack on the NCAA's drug testing program for student athletes. And the challenge was, this is a violation of the California constitutional right to privacy to do drug testing in California. You know, it's an issue I wouldn't have considered very monumental. Drug testing is something that is routinely done in sports competitions, and it involves some privacy intrusion kinds of things. You know, you do a urine test and you observe the urine test. Well, you know, there is an invasion of privacy that goes on there. Well, believe it or not, that drug testing policy of the NCAA was struck down by a California Superior Court. And it went to the intermediate court, the Court of Appeal, and they unanimously upheld it and struck it down. And so it's out. The NCAA cannot operate and do drug testing in the state of California. And that came to my desk, and I said, well, I think my boss is going to want to take a look at that. So I recommended that be granted, and it was granted, and we wrote a decision going the other way. And so that was part of that process. But that is another thing that happens. You know, your judge lets and the judges on the U.S. Supreme Court, I think they all have 3 clerks now. That typically students right out of Harvard, Yale, you know, NYU, Columbia, you know, all of the fancy East Coast schools. We get once in a while we get somebody from California that joins that group. But they will advise their bosses, and their bosses will advise them. Their bosses will say, well, we're looking for this and we're looking for that. And their bosses will know the areas in which these judges are interested. For example, right now, religion is hot stuff in this court. This court has several judges that are interested in religious legal issues, and they're looking for cases. They haven't come out with a lot of religion stuff yet, but we're going to see it. It's going to happen because they're going to shop around, and sometimes it takes years for this stuff to unfold. You know, and that's because of the whole process. The case has to get to the top of the system, so that takes time, and then it has to be picked, and then it has to be put on the docket. Then the court has to decide it, and all of that kind of stuff takes years usually to unfold. But that's the direction in which we're heading. But no question, federal law is supreme, and that's what's pointed out here. But note, there is no number. You haven't read anything. Search that document, you won't find a number of justices for the United States Supreme Court. That is not in the Constitution. We have had 9 justices since the 19th century, right after the Civil War. We had 6 when the court started. Of course, 6 is a little bit of a problem with having ties, but they didn't have ties at that time. And it was a consensus court when it started. And the 6 judges usually would be in one place. Maybe once in a while, 1 or 2 of them would dissent, but they didn't have a problem with 3-3s. What happened in the case of a 3-3? We've had this happen a number of times in the U.S. Supreme Court, where maybe somebody is disqualified. Some judge has an interest in the case, they're disqualified, so we have a 4-4. What happens?
Lower court.
Lower courts upheld. Lower courts upheld, and it does not contribute to the law in any way, because the U.S. Supreme Court never wrote an opinion when that happens. When there's a 4-4, you write nothing, you just say lower court affirmed. Okay, so there's no number. So by the way, this is a way in which you can change the institution if there's a desire to do that without amending the US Constitution, which is practically impossible to do. If you want to change the number of justices, that can be done by congressional legislation. Congress can pass a statute, the president can sign it, or legislation. All of a sudden, instead of 9, now we have 12, or now we have 15, or now we have, guess what?
So on this first section 1, it says, shall hold their offices during good behavior.
Yeah.
What does that mean and who enforces that?
That's the next slide.
Okay.
We'll get right there. Okay, just one more question on this. Why do we have inferior courts? Well, the United States Constitution, there was an intense competition between the Federalists, who wanted a strong federal government, and the state power people. And most of the people that came to the convention were prominent people in their states. And there were, of course, only 13 of them at that time, but they looked to their state as their stopping place politically. And so they were skeptical of anything like a whole bunch of inferior federal courts that are sitting in their state telling them what to do. That was something they were not fond of. That's why this became a matter of something Congress had to create rather than something they put in the Constitution. You know, that was a compromise, one of many. This whole document is a product of compromises, very vigorous ones too. Yes.
Sorry, since most of the cases are not gonna be picked up on those 8,000 that you see or 3,000 cases in California, what happens to the rest? They just done?
They end at that point. They end whatever the decision of the lower court was.
Okay.
Well, that's the final decision. Then in that
And
case.
you said each one of the judges takes the boxes and goes through that, so
Yeah.
I will imagine that not always come with the 80 that they like for the year, and they have to be a discussion about.
Yes. Yes.
To get to the 80 amongst them.
The rule in the United States Supreme Court is it takes 4 votes to grant certiorari or review a case. Now, you notice that's not a majority of the court. It's one less than a majority, but any 4 can grant it. And yeah, they will differ and they will have some discussions when they do all this voting. The first thing they do when they come back in October from their time in Yakima or wherever they were, is they decide all of these petitions and they'll sit down and I'll have a discussion if they need to have a discussion and they'll vote. You know, and they'll put these decisions on the box.
That was 4 votes before with just a 9. What is it now with 12?
You don't have to.
We don't have 12 yet.
Well,
I
that's what
will.
we'll be looking at.
I will say that may be the next step. But there are all kinds of ways you can change that. The concerns, well, of course, let's get to the good behavior. That raises that issue. So, okay. The second sentence here in the Article 3 that I've given you, the judges of the Supreme and Inferior Courts shall hold their offices during good behavior. Kind of a strange spelling of behavior. That's the old English spelling. And shall at stated times for their service receive a compensation which shall not be diminished during their continuance in office. Those salaries, by the way, are about $272,000 for associate justices, and the chief justice gets a little bit of a bump there to $287,000. So these are the protections of life tenure and what we call ratcheted salary that cannot be reduced from the number it was when you started. So, okay, during good behavior, what does during good behavior mean? And where did we get that? Well, it means that the judge is removable only by the impeachment process, which is set forth in Article 2. And that's the process where the House of Representatives impeaches, comes up with a list of charges, and there's a trial held in the Senate, and the Senate determines whether or not somebody is removed from office. And the judges are subject to that, just like other public officials. So they're treated all as the same with respect to that impeachment process. And that's not in the Constitution, but that is the way this has evolved. Good behavior is what the Senate says it is. And boy, you know, how much? But I mean, ultimately, if effectively what this means is a crime, certainly a serious crime, like a felony, would not be good behavior. But there may be other conditions. We've had only 15 impeachments. This is of judges now we're talking, and 8 removals in our history. So this isn't much, you know. And where did this come from? You know, it came really from English practice, and one of the things I got a fantastic opportunity in my life to do was I studied and obtained a graduate law degree from Cambridge University in England. Beth and I went and spent a year in England. And one of the things that I studied there was English legal history with a man named John Baker, who's written a shelf full of books. He could fill any of the shelves here with the books that he's written on English legal history. So I learned this stuff from him. And one of the things that we talked about and considered that year was the Settlement Act of 1701. And this is English Settlement Act of 1701. In 1701, the English had been through a revolution in the previous century, in the 1600s, beginning with 1640, ending in 1660. England was a mess. They had a revolution where Parliament essentially, and that was a group that was revolting against many of the things the monarch was doing, the king was doing. King and Parliament went to war over who runs this country. And they resolved that situation. It took them many years to do that. They had a period of time where they didn't have a king, and then they brought back the king, and then, you know, then they had reduced powers. But when they got to the end of it, they settled all these differences in a series of settlement acts at the beginning of the 1700s. And as to the judiciary, they had some serious problems. The Stuarts, who were the prevailing monarchs, the prevailing kings in the 17th century, had a practice of cleaning the bench. They didn't like the judges, they fired them all. So all the central courts of England, you know, about 12, 15 judges, all of a sudden, you know, had to hit the road and you know, they're homeless and now they're looking for somebody to support them. I mean, literally that happened a couple of times in the 17th century, very disruptive for the administration of English law, and rarely justified. The English judges were by and large doing very conscientious jobs, and this was just arbitrary conduct by the monarch. And it was happening, it only happened once where they cleaned the whole bench, happened other times selectively where they pick out this judge or that judge, decided they didn't like them, and threw them out. Well, you know, the parliamentary group, including all the lawyers, the barristers in Parliament, said, "Oh, come on, we can't operate this way. This is just, you know, this is chaotic. You know, all of a sudden the bench is gone. All of a sudden the chief judge of this court's gone. We can't get cases through. We can't do it. this is ridiculous. And so that's where you get the good behavior language and the protection, because it's in the Settlement Act. And we borrowed it, we took it and placed it there. Now, what happened in England is effectively, the House of Lords had that power to remove judges. So they would occasionally remove a judge. Boy, I did some research on this once, and I could only find a few examples where they actually kicked somebody off. And it was usually for some misconduct in relation to the judicial office. You know, they took bribes or they did something, you know, so that was the way it evolved. And that's why we interpreted that pretty conservatively, as, you know, just put it in the impeachment process. Let's see what the Senate thinks. Otherwise, they have a job for life and guaranteed them that tenure. But of course, what's the problem, guys? In 1701, first of all, people didn't live as long. So you tell somebody you're a judge for life, well, what were you giving them? You were giving them 10 years, 20 years, maybe. But very rarely do you see anybody sitting there for more than 20 years. So that was, you know, they were pretty comfortable with that. The other thing that was a little different is the whole English Revolution was about whether the king or parliament runs this country. The decision was, it's parliament, subject to a whole bunch of rules. Well,
He's teaching us about a lot.
Parliament then has the power, the ultimate power, to override any court decision. This was, by the way, what we were fighting about recently with respect to Israel. Israel wanted to insert, haven't done it yet, but they wanted to insert the power of the Knesset, which is their single unicameral, we say, one house legislature. They could simply overrule any court decision by taking a majority vote. And it's gone. And so, but that's literally what they had in England with Parliament. Parliament had that power. Now, Parliament didn't use that power very much. I'm aware of some examples where Parliament really got caught in a public firestorm because there was a debate about some right being taken away. This happened when Beth and I were in England. One of the things that came up is that Tony Blair and the government at that time wanted to take away the right of habeas corpus, having to do with any enemy combatant, anyone who we arrest on the field of battle or anywhere else, including in the country.
During the Iraq War, yeah.
Yeah, Iraq War, exactly, Iraq War issues. But they have no rights. They have the right of them to come to get a habeas corpus review. What habeas corpus does is it says the court now can review whether you're being held legally. So you get a legal review if you bring a writ of habeas corpus into an English court. Well, couldn't happen, you know, according to Blair and his government. So he put a bill in the House of Commons that said that. The House of Commons, his party, passed it. And it goes over to the House of Lords. The House of Lords, I thought it was a joke when I came to England because it was on television. You know, they have BBC has a million channels over there. They're constantly giving you all kinds of things that are going on. So they had a channel that was literally devoted to whatever is going on in the House of Lords. Well, you tune in most of the day. First of all, you can't see anybody there. And you're looking, oh, there they are in the back row, and they're sleeping. You know, some older people here, and they're in the back row, you know, and so you get the impression of what the heck are these people doing? Well, this bill goes over to the House of Lords, and wow, they all show up. And they not only show up, they got on their feet, and in terms of rhetoric, you know, Pastor Derek this morning speech, they give some of the grandest speeches you've ever heard about the dearest birthright of the people of England is habeas corpus, the right to make sure they can't be imprisoned, they can't be seized, they can't be held. without a chance to come into a court. And wow, the heat was so great. Clear back down. They pulled the bill and it did not go through. And that was press coverage, that was all that kind of thing, but that's the English approach. Parliament could have done that, but Parliament didn't, and Parliament doesn't often mess with the fundamental rights that are in Magna Carta, coming from 1215 and thereafter. But so, okay. We have this, it's designed, of course, to assure judicial independence. The Federalist Papers are a source we constantly quote. Federalist Papers were a bunch of papers written by Alexander Hamilton, James Madison, and John Jay. Just a few in the case of Jay. And they were written to try to get the Constitution passed in the state of New York. They were worried that the state of New York was not going to ratify the Constitution because they're going to have a public vote. And there was a lot of controversy about whether we ought to have this new Constitution in New York. And so this stuff all got published in the New York papers. And this is their advocacy of what they had done in the Constitution. Well, Hamilton was the one that took control of a series of Federalist Papers on the judiciary. And he says judicial independence is a critical value. Good behavior will promote judicial independence, meaning the steady, upright, and impartial administration of the law. And he invoked the experience of Great Britain in support of this good behavior standard. And he said, and this is extremely eloquent, Federalist, judges are the least dangerous branch of government. Excuse me. Not a lot of foresight there. But note his reasoning though. The reasoning makes sense. Because they have neither purse, they can't control the expenditure of money. The legislature gets that power. Nor sword. They have no authority to enforce even their own decisions and decrees. That belongs to the executive. The executive has enforcement power. So they're only dangerous if they are allied in some way with the other branches, if they're all checking and balancing each other, and if the courts are reviewing and occasionally striking down decisions of the other two, we won't have that problem. We'll have independent justice and we'll have balance. That was the idea that came behind this. And it's, of course, the problem with this is you give people life tenure. Well, and the other problem is you don't, from all that discussion about England, you don't have what we call judicial review in England because Parliament can override it. So a court can't say something is unconstitutional. Here, my goodness, it's a sport. The US Supreme Court has authority over federal and state legislation to strike that down as unconstitutional. And so that is a very important, but very powerful thing in dealing with the relationships with government. And they didn't have that at the time of the Settlement Act of 1701. Maybe if they'd had it, they would have written something different about good behavior or when judges and how judges can be removed. The judges don't have any kind of term limit or anything like that. There are two sets of problems that are normally complained about here. One is the loss of mental acuity with age. And, just the usual problem. Judges get old and some, we had one in California that literally got senile on the bench. And, they didn't know what to do because he kept showing up. He kept voting, and what are they going to do? He one day, so the story goes, he wet his pants. He was walking into the court building and he had 10 watches on one sleeve. And finally, what they did, his wife was made conservator. And she resigned on his behalf from the court. And that's how they resolved that particular cause. So, okay. Now, so I leave that to you as a matter to consider. Is this the kind of thing that we want to do here? Do we want to have some kind of limit, based on age or based on how many years you've been there? Because the power that is wielded by judges with judicial review of all this legislation, that's all, by the way, democratically enacted by legislatures, Congress, state legislature. Do we need some check on that by saying you can serve for 10 years, but that's it? Or you can serve for 20 years and that's it. We can't do that now under the current Constitution, but we could say we can start packing the court. We can start adding judges. If people have been there longer than 10 years or 15 years, we're going to add something, to compensate for that. But anyway, so there are a whole bunch of cases, and I'm not going to spend a lot of time with these, but there are types of cases that arise under the Constitution that the court has jurisdiction to decide. There are all cases in law and equity. First of all, that's a statement made before they list the categories. What does that mean? Anybody know? Or why would you put something like that in there? We're going to have cases in law and equity, and then here are all the categories, subcategories of cases. Law and equity refers to the different kinds of courts they had in England that we had duplicated here, where you have two sorts of things the court does. You have a law side where the court applies either criminal or civil laws, and you have usually a single judge doing that. But sometimes a single judge would have a jury sitting in a civil case where there are damages, in a criminal case where there's a crime charge, you'd have a jury. But then in equity was supposed to be available when the law maybe had some gaps in it, maybe it wasn't quite fair, maybe there should be an exception of some kind of way in which the law could be qualified because of the way it operated was harsh. That was the equity side, where a single judge sitting in equity would say, no, we're not going to apply the law in this case, because here are the good reasons why there needs to be an exception. So they had both sides of that. Therefore, the Constitution says both of these come under this jurisdiction. So whether it's a law situation or an equity situation, that's all part of what can be reviewed. I won't go through all of these, but if you have, for example, cases between two or more states, you have any case involving a law of the United States. A regulation would also fit because that's a law arising under a law of the United States. A treaty, any case affecting ambassadors or consuls, public representatives of the United States or other countries. Lawsuits between a state and citizens of another state. Notice all of the interest here, differences between citizens and foreign states or between different states. That everybody wants that in federal court. Yeah, Bob.
When you were talking about the courts and the equity and all that stuff, and then the initial courts are just gonna follow the letter of the law, but when the equity come in, would that also include like congressional history? Would they look at congressional history as to applying the equity of the laws?
The court in equity has discretion to look at anything that has to do with fairness. And of course, the problem with that is you can't make a wholesale exception to all laws, right, by just going to equity. So guess what? Equity becomes very legal. You get situations where we will depart from the law and situations where we will not. And so that all develops under the title of equity. And this is when we'll make an exception. This is when we won't. you know, that kind of stuff. Yes.
The issue between states, could this be applied to the controversy between Newsom and DeSantis, Florida and California?
If the states get into litigation over that, yes. Then that's automatic US Supreme Court jurisdiction. Most of the time, Fred, where this has been applied has been over things like water rights and boundary disputes. That's typically where you have two states fighting about something. When you have a couple of governors duking it out here, there has to be some kind of theory. But you know, just thinking about it off the top of my head, I think that might fit. I think we might be able to have, you know, Newsom might call up Rob Bonta, his name is, our Attorney General, and say, well, let's do the wee out of Florida. You know, let's bring a lawsuit. And if they did, US Supreme Court would hear that right away. Now, what is the US Supreme Court going to do with that? I don't know.
In such a case, would the Supreme Court be the original jurisdiction for that case?
Yes, and that's the other thing, is original jurisdiction. What's the difference between original and appellate jurisdiction?
They're the first to hear it.
Yes, original jurisdiction means the Supreme Court is the first to hear the case. And it's their case. They don't get it because some other court decided it and it gets appealed to them to review the other court's decision. No, they make the decision. So if it's California versus Florida, that's the US Supreme Court says, and they hold a trial. Now, by the way, they don't do that. What they do in the cases where they take original jurisdiction is they will send a special master. They'll appoint somebody to go out and hold a hearing and gather all the facts and then present them a report as to what the facts are, and then they will decide the case based on the report. That's the way they do it, because otherwise they could be spending a lot of time hearing this. Yeah.
What happens with special appointed people that do research and then say, yes, you should go to court or not? For example, with the case with Trump now, there was that special. Yeah,
Right. Well,
so what, when they reach level that person comes in?
well, this person, in the case of Trump's prosecution,
Right.
They appointed a special prosecutor to handle that. He is treated just as any other member of the Justice Department who's a lawyer who's been assigned to prosecute a case. So he has all the powers of the Justice Department behind him. And he literally, to preserve his independence, he has his own staff, he has all of that kind of thing. And he then will go to court for Trump. So he'll be the one that appears down in Florida when they have a trial of this case about the Mar-a-Lago documents. By the way, we don't have time to get into this. I would love to get into this because I am not a big fan of the way strategic decisions were made with respect to this case. I'm a lawyer, and the first thing I have to do is try to win my case. If there is a way to do that, I'm not trying to impress anybody politically. The first thing I do is win, and if then I worry about impressing somebody politically, but I don't plan the case politically. This case has been planned politically, and where this is venued. And you know what this reminds me of? This case is going to Florida. That's not the best venue for it. Best venue would be Washington, D.C. For both for juries and for judges. Now, this judge that's already heard it and loves Trump is going to hear this. This is not a good place. Not a good place. The other thing, folks, and you may have picked this up at the time, it was not emphasized in the press, but the O.J. Simpson trial. Remember back in the 1980s, O.J. Simpson? Well, how come O.J. Simpson got his case tried in the central Los Angeles courthouse, where you were going to have a jury panel that is going to be his folks and nearly all of his folks? How did that happen? because the murder occurred out in the burbs, out in the suburban area, and there were courts, there was a Superior Court out there. Much different jury panel. Well, the district attorney made that strategic decision to charge that case downtown. And she, when she was asked about that, she said, well, I didn't want to drive all the way out there.
That's a good.
And I went, you gotta be kidding me. You literally have to be kidding me. But in any event, that's what, that's what happens. Okay. Trial of all crimes has to be by jury, says Article 3. And the last thing I was just gonna say, just a bit about this, and I won't go through all these last 2 slides. I want you to watch for something when we start talking about these decisions. We'll start this next time with the Voting Rights Act. Courts have philosophies or approaches to how they interpret the Constitution. The reason that's important is look at the Constitution. It is not very detailed or precise in what it states. Free speech, freedom, free exercise of religion.
Right to bear arms.
Right to bear arms. Oh, here's mine right here. But I mean, what did they mean by this stuff? And how do you deal with this? Well, there are roughly two, and I'm really kind of simplifying all of this theory, but there are roughly 2 camps about this. There is what's called the originalist group. And this comes right out of the organization called the Federalist Society, which is a largely conservative organization that loves to vet judges. And we have a couple of judges sit on the US Supreme Court that are big members of this society. These people are believe in a philosophy that you look to the understanding of the time the Constitution was enacted. So you can do this in 1 of 2 ways. You can look to the framers and ask what was their intent. And this way you would look at things like the minutes of the debates that they held, which we have, and ask, well, how did they debate this and what did they say? You might look at the Federalist Papers too, as background. For this. James Madison was certainly a major figure in the Constitution, and he wrote many of the Federalist Papers. So you look at those things as sources and just ask, what was the intent of the framers? The second part of this goes, wait a minute, no, this isn't the intent of the framers, for goodness sake. The Constitution starts, we the people of the United States do this. So it's not the intent of the framers, it's what the people understood that to mean. So you look more broadly and try to get an understanding of what was said to people. And there were raucous debates when the Constitution was ratified by the states. And you try to develop some meaning out of that. That's called originalism. And you will see this approach. Many of the judges, as a matter of fact, a majority now of the US Supreme Court are originalists. They're looking for that original intent. However, there's another approach called pluralism. And pluralism means, look, we can't get that much out of what happened in 1789. We can get some things out of it. We can get maybe a principle, something they're trying to do, but we have to adapt to modern times. We can't go with it. Just like, for example, you've seen some of the kind of funny commercials about firearms, that go around, and of course you got a musket in 1789, and you couldn't hit the broadside of a barn with it, unless you were specially trained, and then you didn't do that much better, So things are different now. An AK whatever is going to just blast the living what out of anything. and they didn't have anything like that, 1789. But I mean, so these are the kinds of things that enter into what do you do? The originalist wouldn't care. He'd say, no, is this a firearm in 1789? Do we have firearms now? Okay, that's the same thing, let's go. I mean, so this is kind of troublesome things. Yes, ma'am.
Your previous slide talked about ripeness.
Yes.
What is ripeness?
And
it was there twice.
well, like at this time of year, a lot of the fruit is really, and some are really ripe, but some of it, you know how you buy a piece of fruit and you buy it, intentionally buy it, and it's not ripe. It has to sit there.
Green bananas.
Yeah, exactly. You do that. Well, this is the same philosophy with respect to cases. You might have a potential law for you, but nothing has happened yet to trigger that problem. Maybe somebody, some organization has passed a law, but maybe they have at some local level or in the state legislature, they have reserved the right to make some exceptions to it or to refine the way it's being enforced, and nobody has been affected by it. It's not right. That's not ready to go to court. To go to court, we've got to have some facts, we've got to have a violation, we've got to have somebody that has broken some covenant or violated somebody's rights. If we don't have that, we don't have anything for the court to chew on. Okay, I think we're at our time, and I think we'll stop right there. I didn't get to talk about gun control, but I will do that briefly next time. Okay, anything else before we adjourn?
Well, I
Yes,
just
sir.
saw, something about the Second Amendment that I've always heard about, is that originally it was not considered to be individuals owning guns. It was about just the ability of, exactly.
A well-regulated militia
Exactly.
being essential, and so we'll talk about the grammatical debate there next time.
Yeah, I mean, basically.
What?